From the Library of Congress in Washington, D.C.
Okay, welcome back, everyone. We are going to start session 5, the last session of the day. This session is on permanent exemptions, and I'll just read the description. This session will explore the necessity, relevance, and sufficiency of the permanent exemptions to the prohibition on circumvention, and we'll consider whether amendments or additional exemption categories may be advisable. So to get started, I'd just like to ask the panelists once again to introduce themselves and along with their affiliation.
June Bessick, Kernighan Center for Law, Media, and the Arts at Columbia Law School.
Gabe Gasares, Government Affairs Specialist, National Federation of the Blind.
Krista Cox with the Association of Research Libraries.
Troy Dow with the Walt Disney Company.
Harley Geiger with Rapid 7.
Matt Williams, I'm here on behalf of AAP, MPAA, and RIAA.
James Love with Knowledge College International.
David Perry with the law firm Blank Rome on behalf of Dorman Products, Inc.
Chris Moore, SIA.
Marina Cabarizzi, no affiliation. I'm here as a concerned member of the public and IP law enthusiast. Thank you.
And a proud alum of our office. So welcome all. So I thought we would proceed sort of in two parts. First, by looking at the adequacy and the functionality of the current exemptions, and then turning to proposals for additional permanent exemptions and to get your thoughts on whether any may be necessary or advisable. We're thinking of proceeding a little bit differently in this session. As you know, a lot of the existing permanent exemptions are specific to particular types of uses and are maybe more relevant to particular, to certain of you than others. So we may direct questions specifically to individual people to start out with, but everyone obviously is welcome to weigh in, and in fact, we encourage you to do so. So I wanted to start by talking about the library exemption under Section 1201D. We received a number of comments on this exemption from library associations. I think the word useless came up in one or two of them. And so if I could direct this to you, Ms. Cox, I just would be interested sort of generally in your perspective on the current library exemption, if you could sort of elaborate on why it may not be as useful as hoped, and any changes you would like to see.
Well, I certainly think that Section 1201D is not very useful for libraries, archives, and educational institutions. It's not actually an exemption that we asked for in the DMCA legislative hearings and that whole process, because it's so narrowly drafted. It's not an exemption for any nonprofit library or educational use. It's not even an exemption for any library or educational use that is already granted under, Section 108 or granted under fair use. It's so narrowly tailored to only acquisition decisions, and you can only use that exemption for the time necessary for an acquisition decision. And it is our view that if we are going out and looking to make an acquisition, that whoever is selling that book or that product to us would be happy to open up that digital lock for us to make that, that determination. We find that we are constantly using, every 3 years, the rulemaking process to pursue the exemptions that we think are really necessary. For example, for assistive technologies for those that are blind, visually impaired, or print disabled, for educational uses of audiovisual materials. So for us, those are the types of uses that we would find that we need continually and that would warrant a permanent exemption versus the very narrow exemption in 1201D.
Thank you. And so just sort of in practice, I mean, in your experience, is the current exemption, I mean, it sounds like the answer is no. Do you know of many examples of librarians making use of that exemption?
I don't, because I don't know of content providers who hand something over to a library locked and say, do you want this product? It's locked. No, I mean, just for purposes of acquisitions, normally the content providers are happy to unlock it for us as we make a decision in purchasing.
Okay. Yeah. Oh, sorry, go ahead.
Can I ask, what are your thoughts about reforming it to track the contours of 108, which is different, I will say, than some of the petitions for exemptions in the rulemaking?
I think that, I mean, I think that there are certainly areas where it would be useful to amend 1201 in order to accommodate what's allowed under 108, but there are, of course, other uses as well that we would support.
Oh, sorry. So, well, yeah, so I think that was one proposal. I mean, I know in our comments from the American Association of Law Libraries, there was a recommendation that a permanent exemption be created for any use that was permissible under 108. I assume, is that something that you're recommending as well, or do you think that the exemptions that you've petitioned for pertaining to motion pictures are sort of a more pressing concern?
Can we have both?
Well,
no, I mean, yes. I think that expanding it to apply to Section 108 would be very, very helpful. And I think this just highlights a fundamental flaw of the 1201 process that has been talked about in these roundtables, that it's not linked to infringement, and it's from the perspective of our libraries who really do want to follow the law and, ensure that, simultaneously ensuring that we are fulfilling our mission, that it doesn't really make sense to have these exemptions granted under Section 108 or be allowed under fair use, but then you can't actually do it just because we've moved into a digital world.
Mm-hmm. Are there any other views on sort of the advisability of oh, I'm sorry, I didn't even see Mr. Williams.
Oh, mine just came on. Okay, great.
Okay.
Thank you.
If we could just ask if you're not speaking to turn off your microphone. Thank you.
Thank you. I did see that the library community is not finding the existing exemption helpful, and it sounds to me like that's because the market is working really well. That, as she said, copyright owners are more than willing to give test access to libraries so that they can sample the works and decide whether to buy them. So I think that's a good news story, not a bad news story that we need to worry about. I in the comments, saw that in replace of the permanent exemption, what the libraries seem to be asking for is all non-infringing uses exemption, and we've talked in other panels about why there are a lot of dangers associated with those types of proposals and why 1201A was designed not to necessarily protect only exclusive rights under Section 106, but also to provide a right of access that is very important and that needs to be preserved. When you get to the slightly narrower approach of just for 108 covered uses, I doubt that that is going to go very far in terms of reducing the number of exemptions that libraries seek, because what I often read, at least, is that libraries and others are unhappy with the scope of 108 as it currently exists, and so they would rather point to Section 107 for most of the things that they want to do, in which case you either get back to a kind of pseudo all non-infringing uses type of approach, or you end up needing, even if you cover all 108 activity, for people to come back every 3 years and make new requests. So I'm not sure that that would have a very effective impact. I think what will have a more effective impact is that if the more streamlined approach to renewals that was discussed yesterday is adopted in some workable format, the need to make permanent these types of exemptions becomes a lot less important, and you actually preserve the ability to have some confidence of renewal, but you also preserve the flexibility of having the rulemaking there so that if someone needs something new, they don't have to go all the way back to Congress again. They can come to you. Thanks.
Thank you. Ms. Besic?
Well, specifically with respect to an exception for 108 activities, I can't help but wonder why the libraries need it now when they haven't made such a request, not necessarily with regard to all 108, but specific 108 activities over the last several years. It seems to me that if the structure were that deficient, they would have consistently asked for that exemption, and it's not there, so I'm not sure there's really a basis. The second point I want to make is I think Section 108 is broader than people might realize. I was on the Section 108 group, as were others here, and you know, it gives libraries a fair amount of flexibility with respect to providing copies for users, for example. And so I don't think that we should assume that that would be a narrow exception. And I think I think it is really akin to the no non-infringing uses, that you should be able to circumvent for any non-infringing use or any fair use. I think it falls in that category, and I would be reluctant to see that without more.
Thank you. Ms. Cox, would you like to respond to that?
Of course, the libraries, Mr. Williams is correct, we do support the Unlocking Technology Act, which would tie infringement to circumvention, but as a next best option, we do very much believe that permanent exemptions are warranted in certain cases. For example, for assistive technologies for the blind, libraries serve as authorized entities that, we're often providing accessible formats for the blind. Also for the audiovisual exceptions for educators and students at our colleges and universities, for K through 12 educators. These are all exemptions that we have supported in the past. And in the most recent rulemaking cycle, the NTIA recommendation to the Register, in that report, it said that they acknowledged the concerns by the right holders who oppose these exemptions, but that emphasizing that these exemptions don't legalize copyright infringement, and that the record doesn't show that the previous grants of similar exceptions have led to piracy. So I think in those cases, it makes a lot of sense to move towards a permanent exemption, to expand our current 1201D exemption to include the activities that are really important to us, like these exemptions that we request every time. I think the Library Copyright Alliance joined 4 different proposals for exemptions for audiovisual classes in this past rulemaking cycle, and it seems like that just keeps expanding. And so I think having a permanent exemption that is broad enough to cover these areas would make a lot more sense than us having to go through this every time, especially when there isn't any evidence that infringement occurs in having these exemptions.
Can you speak to Mr. Williams' point that perhaps streamlining the renewal would serve a great deal of your concerns, while still sort of leaving the door open in case there were changed circumstances in the market or something, or some reason, to sort of not etch it in statutory stone and make it permanent? Could you live with that instead?
Well, I certainly think that streamlining the process would, of course, help, but I'd have to see what the contours of that streamlined process would look like, because previous rulemaking cycles, of course, were I think, much less involved than they are today, where you have a 400-page report from the Copyright Office. I think that if there is a, presumption of or an automatic renewal unless there's evidence of changed circumstances, that would certainly be helpful. But what would be even better, of course, is if there's a permanent exemption where, time and time again, the Copyright Office is granting exemptions for persons who are blind or disabled, for educators and educational institutions, for students in college and universities. I think where there's strong evidence that there has not been infringement as a result of these exemptions, it just makes sense to make them permanent.
Thank you. Could I just follow up on the 108 question? We received some comments that talked about the need to circumvent of libraries to circumvent for example, preservation purposes. And they used the example of works in obsolete format, which may include TPMs in obsolete format. I just was wondering if you could sort of elaborate on that. And I wasn't totally clear whether that sort of issue goes to access controls or whether the issue is copy controls. In other words, if you have, if a library receives a collection of VHS tapes or something, is the issue with respect to preservation that the library can't access the works, or is it more that there is a copy control which would prevent you from digitizing it?
Well, I think with the VHS, it would be a copy control mechanism, not an access control mechanism. I think my colleague Brandon Butler, who actually works in a library, may have more information on this issue.
Okay, no, that's fine. Mr. Dow?
Thank you. So just a couple of points. I served with June on the Section 108 committee, and I had a similar reaction to the proposal that there'd be some sort of exception that would apply to Section 108 covered activities, and that they apply to such a broad range of activities, including things like interlibrary loan, copies for users. I know that in the course of our discussions there in the Section 108 group, we talked extensively about the fact that copies for users for private study was contemplated by many libraries to include loaning of materials and providing of materials for personal review, including loaning of movies and things like that for personal review. And so the notion that you would have an exemption that would allow you to circumvent copy protection to provide unencrypted copies of expressive works as part of interlibrary loan or as part of copies for users, I think would be of concern to us. On the issue of not having evidence of infringement, one of the concerns throughout, even with the rulemaking process, is it's very, very difficult to tie resulting acts of infringement to the particular uses that are being made pursuant to the exemptions, right? And so if you have an exemption to allow people to make copies for a variety of uses, tying then downstream, if the result is that that allows for circumvention to release unencrypted copies of works, then it's very hard to tie the downstream copies of unencrypted copies to the first initial copy that was made. So while there's not an abundance of information in the record to show infringements, it's actually really hard to say what the impact of that is in the marketplace. The last thing I'll say is that in terms of Section 108, the other thing that I think we learned in that process was that's a section that is sort of technologically and market-based dependent. And part of the reason we were gathered together to talk about Section 108 was because technology had eclipsed the statute. And Congress had attempted to make some updates in the context of the DMCA, and even those updates had been eclipsed by time and by technology. And so I think in that sort of context and the types of things you're talking about in 108 for things like preservation, there's a benefit to having a rulemaking process that can respond to those changes in the marketplace, to the specific technologies that are being used, to the specific concerns about what the impact of allowing circumvention in those circumstances would be, that would allow not only streamlined access to those exemptions along the lines that was discussed, but also to have exemptions that are tailored to the particular needs and to the particular concerns, and much better than you'd be able to do with a permanent exception that you might find yourself looking at that very much like 108 becomes quickly outdated.
Thank you. Mr. Love?
Thank you very much. If the permanent exceptions are by statute only, and the statute sort of sets out all the conditions, I think that the problem in the past is you end up with a fairly narrow statute that is frustrating for people who are supposed to be the intended beneficiary of the statute. a better approach in our mind is if a statutory mandates an exception but permits the Copyright Office to provide more information about the contours of the exception at a later date. Like, so for example, if the statute, let's take the issue of the uses for people who are blind, if it was to address the obligations in the Marrakesh Treaty for people with disabilities. If the mandate was broad, but there was some sort of understanding that there could be at some point more context or information provided if necessary, by the Copyright Office down the road, it might be a better situation than trying to spell out every particular issue that you might want to do by statute. Another thing I think is important. I mean, we think that the idea of more or less permanent exceptions. I think permanent's a funny word because nothing's really, even in a statute, permanent. So I think what you're talking about is durable and persistent exceptions. And so I think the Copyright Office surely should be able to do the 3-year thing. I think is a mistake. I think a lot of people have talked about that in other panels. One of the reasons is there's a high cost of developing and implementing both the tools to use the exception and, as important, I think, the standards and the best practices for implementing exceptions. Now, if you want to have a conversation, for example, among authorized entities for people that are blind, or you want to talk about archivists, or you want to talk about maybe auto mechanics or whatever group you want to have, for them to sort of sort out the problems of the different stakeholders so that they're not just looking at their own interest, but they're looking at the interest of third parties that are affected by the policies that are implemented. That can be a pretty complicated thing. And then you want to, and then you have like a small number of people, like the number of people in this room can kind of figure out what that rule should be. And then you want to like educate like thousands of people, as to how to sort of use that standard, and so that they do it in an appropriate way. And then you sort of say, but this whole exercise is going to be revisited 3 years from now. I mean, it's kind of defeats the idea that you're really serious about doing it in a thoughtful way where you have buy-in and implementation that's really consistent. So I think that one of the reasons for the more persistent and durable exceptions is the fact that it really is time-consuming and costly to design the tools for exceptions and to implement them appropriately. Thank you.
Thank you. Mr. Williams, did you have?
Just a quick point to go back to something that Troy Dow said on evidence of harm from any of the existing exemptions. He's absolutely right. It's almost impossible for us to collect data to show that someone who used the exemption ended up circulating pirate copies on the internet. On the other hand, in every cycle, I think since the AV Works exemptions have been in existence, we have pointed to examples in the proponents' comments of uses that we think are likely to be infringing. They are not uses that my clients have had any interest in pursuing litigation over, and calculating the actual harm involved is quite difficult. But I just wanted, for the record, to note that we have each cycle come across uses that the proponents have said are examples of how they're using the exemptions, and our response has been, well, some of these are actually probably unlawful.
Great, thank you. I want to go back to Ms. Cox, and then I think we're going to move to the next topic.
Just because 108 has been such a focus of this discussion so far, I just want to say that there have been some criticisms that 108 is out of date and therefore libraries just look at fair use. And while it's certainly true that fair use is critical to libraries, we do use 108 every day. I mean, I talk to any librarian that I talk to, they say, of course, 108 is still relevant. It's still something we use. Is it as good as fair use? Probably not, because fair use is adaptable and it is flexible enough to accommodate these new technologies. But 108 is not an obsolete statute. And just with respect to whether it's hard to get evidence of downstream uses, while I acknowledge that, yes, Mr. Dow and Mr. Williams may be correct that it can be difficult to trace back exactly where an infringing copy came from, I certainly hope that you are not suggesting that libraries and educational institutions are using this exemption and passing out infringing copies.
Thank you. So I think now we're going to move to talk about the reverse engineering, encryption research, and security testing exemptions. As you may know, in the 2015 recommendation, the office found a compelling case that 1201F, G, and H are inadequate to accommodate their intended purposes. So I just would like to start with a general question. I'd like to ask your views as to how these provisions might be amended to more effectively facilitate legitimate reverse engineering activities in security research. I think this may be particularly relevant to Mr. Geiger and Mr. Moore, but others, of course, are welcome to comment as well.
Thanks. Well, just a couple of preliminary points. Essentially, from our perspective, we believe we don't. I'm not sure we share the office's conclusions on this particular point. We believe that the current statute is working, that it can work. And let me just address a couple of things. I mean, one of the things that I have heard today that probably would cause my members a bit of heartburn is some suggestion, maybe implicit, maybe not, that software is, let's say, a second-class copyright citizen. And that is something that we wholeheartedly reject. And we heard that, I think, in some, as if one can separate the function from expression easily. I have looked at a decent number of cases examining these issues, and that's not an easy line. And it hasn't been an easy line basically for a long, long time, and that's true not only with respect to computer programs, but it's also true with respect to cheerleader uniforms and plays and all kinds of idea expression. It's the same line, it's expressed in different ways, and it's a really fuzzy one. With respect to the exemptions themselves, I mean, we believe the reverse engineering exemption is adequate. With respect to security testing, our members have relationships with the security testing industry. If there are areas in which voluntary agreements may be useful to kind of allay Section 1201 concerns, we're certainly open to discussing those. But at this time, we don't see any need to open up the statute.
Can I ask a more targeted question about 1201F, the reverse engineering statute? So in the rulemakings and yesterday, we heard a lot about, how 1201 was not intended to prevent, a lock-in effect for printers or garage door openers or something. And when I read 1201F, it says you can, circumvent for the purpose of identifying and analyzing elements necessary to achieve interoperability. Do you have an opinion on whether it makes sense to reform 1201F to include, things necessary to enable interoperability? And I think the Breaking Down Barriers to Innovation Act, has some specific language for that too. I mean, what are your thoughts on going beyond, I guess, identifying and analyzing into helping facilitate interoperability?
I think that if my recollection is correct, and it very well may not be, that this particular, that the standard in 1201F came out of existing case law. I can't recall which case. I would have concerns about the breadth of the concept of facilitating interoperability. Covers, I think, a wealth of sins, and many of them could lead to pretty bad things for a lot of my members. So I'm not, color me skeptical about that particular proposal.
Mr. Geiger?
Thanks. So unsurprisingly, we disagree that the statute is currently working with regard to security research. The temporary exemption is a big deal for us. It is extremely helpful. But that aside, in talking about the permanent exemption, as it stands right now, 1201 does chill very important security research that will help prevent harm to individuals, and it will help prevent breach of sensitive data. And we gave you an example in our comments. We have a researcher that is employed by Rapid7 who is a diabetic. He wants to research his own insulin pump, but was prevented from doing so prior to the temporary exemption because of 1201 of the DMCA. In addition, a lot of independent security researchers, folks that are not necessarily employed by us, but that we work with to help improve our own security products, they are chilled. That is, they don't engage in the research to begin with, or many of them actually receive cease and desist letters that reference the DMCA. This is, again, prior to the temporary exemption. So we don't think that it works, and we think that this issue of security research and software is becoming a lot more important. As discussed previously, we are seeing this explosion of software, both in the physical world and virtually, and there are a lot more security flaws than there are people to fix it. And in many cases, manufacturers either don't know about the software flaws, or they're willfully ignorant of them. Part of the problem with voluntary agreements, and this goes to the requirement of authorization in the permanent exception, is that it hampers independence. It means that the manufacturer themselves gets to control completely how the security research takes place and what the publication is like. And if you're a manufacturer that doesn't support independent security research, or if you are a manufacturer that has something to hide, as Volkswagen, for example, might, then that will make the research a lot less effective and not as independent. There are also several other problems with the permanent exception, one of which is this requirement that it violate no other law. The CFAA is very, very broad. It's very ambiguous. It is the subject right now of some pretty sharp circuit splits. So you're importing a lot of the ambiguity from these other laws into 1201, laws that have their own chilling problems, and doing it largely for non-copyright reasons. There's also a part of the permanent exception that says that the information derived from the research cannot be maintained in such a way that could facilitate infringement or violation of another law. What happens if you're a security researcher and you've contacted the manufacturer about a problem in their product? They do nothing, and standard practice is that eventually you will make that disclosure public.
Well, doesn't the statute sort of contemplate by that by saying it's a factor that should be considered, and maybe in that specific use case it would make sense to not stick it with the manufacturer but to go broader?
Absolutely. The fact that it's just a factor as opposed to an outright requirement, sure. But both factors are cutting against the security researcher, right? One is, if they've publicly disclosed it, and others can then use that for nefarious purposes, which is part of the point, right? Part of the reason why you publicly disclose is to encourage the manufacturer to actually correct their flaw if they haven't been previously. And then the second was whether the information is solely for the purpose of benefiting the manufacturer, the owner of the computer system. And a lot of times security researchers are doing this for the benefit of the public, not necessarily the owner of the computer system. I want to make 3 other points really quick, because we've talked about this.
Keep it quick, because we'll have follow-up questions.
I'll talk about it quickly. We talked about this in previous panels, right? So this idea of embedded software exception, or in the temporary exception, we're talking about consumer devices. These lines are blurring, right? And things that are embedded in software now may not be, or embedded in devices now may not be in devices in the future. Consumer devices, likewise. Security researchers work on more than just devices. They work on networks. They work on completely virtual software. And what counts as a consumer device is also, in many cases, a business device, or is used by infrastructure. And we want to encourage that kind of security research. So, thank you.
Oh, I'd like to ask you a follow-up, and then others can weigh in as well. It's sort of a more general question. I mean, you mentioned the multi-factor framework that both 1201G and J provide for. As a general matter, do you sort of think that type of framework is helpful, where there's sort of a multi-factor analysis that a court can take into account, or does that in itself provide, sort of reduce some of the certainty as to what's permitted and under what circumstances?
It absolutely reduces the certainty. And in our opinion, we'd prefer to see a blanket security research exception for things that are not, for the sole purpose of improving the safety and security and correcting software flaws. So I would kind of cut it off right after the definition of security testing. And in many cases, we are seeing agencies move to protect the other types of equities that you see in the permanent exception, like privacy, like safety, the NHTSA, the Transportation Security Agency, as well as the FTC and others. Like they are already moving to protect against hacking that in ways that violate privacy. We've got laws for that. So it's unclear to us why 1201 ought to be the vehicle, so to speak, to prevent those types of activities. I will also say that when it comes to trafficking, we because we are a penetration testing company, we actually do use software. We market software that can be used to circumvent. And some of that includes circumventing passwords or brute forcing encryption. Companies, this is very valuable to them because they want to know what flaws they're susceptible to. And so we have to traffic in that software in order to run our business. And we work with security researchers that send us updates and exploits. They traffic in circumvention tools to us so that we can keep our products up to date. So this is an important component of security research. And I'm saying this because I wouldn't want to see trafficking fall by the wayside if we're talking about reforming the permanent exemptions.
Thank you. Mr. Williams?
Thank you. I'm primarily here to talk about books and music and movies, so some of these issues are to a certain degree separate from those interests. However, I do have some concerns that if you start taking a lot of the limitations out of some of these permanent exceptions, that there will be unintended consequences that will impact the industries that I'm here representing. I went through the statute this morning and had the pending legislation and started marking through the portions that would be deleted, and a lot of the safeguards that Congress decided it made sense to put in there are being taken out, and some of that might be for perfectly legitimate purposes. I can't speak to that, but some of it could cause some harm. And so I'm skeptical of whether it's necessary, because usually when Congress decides to amend an exception that's already in the statute, there's a number of cases that have come through the courts. They've either come out the wrong way, or there are a lot of indecision between them when you compare them. And I don't think that's been the case here. There's been a lot of debate in the rulemaking about what the existing exemptions would allow or not allow, but I haven't seen much in the way of litigation to point to. So I think to take it to Congress without those types of badly decided cases, it might be a bit of a stretch. I mean, I can think back to when the last sentence of Section 107 was added, and I think that was 1992. There was 5, 6, 7, I think, unpublished works cases that took place before Congress decided we should add this sentence that just basically says if it's an unpublished work, it might still be a fair use.
Well, can I ask you a follow-up question? Because I take your point about treading lightly on statutory reform, but we do have this rulemaking process where if the permanent exemption isn't working, perhaps you're not seeing litigation, but you are seeing petitions before the Copyright Office, and the security testing might be such an example where they said the requirement that there's authorization from the owner is not working for us. Could you grant us a different exemption? I think in prior rulemakings we thought that more specific for certain devices, but there's sort of a repeat echo of security research being something, if properly defined, that might be permissible through the exemption process. I mean, would you oppose maybe not crossing out all of the statute, but for example, that specific, could you speak to specific reform proposals, the requirement of authorization being one of them?
I guess I would say again that I think that the easier and preferable route to addressing those issues that have already been raised in the rulemaking is to do the streamlined renewal process, as opposed to taking this to Congress and asking them to rewrite the statute. One, because I am worried that there will be unintended consequences, but two, because I also think it's such a difficult task to draft it in such a way that no one who's writing a law review article is going to be able to come up with a hypothetical case that would come out the wrong way, and then people are going to have to come back and present issues to you guys anyway. So I'm not so sure that that trying to rewrite it will actually fix the problem of people needing to bring to your attention issues that are of concern to them. I'm not ready to go through line by line on the things that have been proposed to be taken out and give you a position for my clients on each one of them, but the things that concerned me were the completely striking out the factors to be considered. As you said, they're just factors to be considered. Violations of other laws in the context of these things, that also I think is something that would have to be thought about very carefully.
Thank you.
I'm sorry, I had one last thing that I originally
Sure.
intended to say. I apologize. One thing I would just ask you to do if you do decide to make recommendations in this area is if you'd go back to, I think, 2010 and earlier rulemaking decisions, there were issues that came up about whether or not you're entitled to access a movie or another expressive work on every different type of device that you might want to access it on. And the office consistently concluded that that's not the case, that you don't have that right. And I would just ask that if you make changes in this area, you take a look at those prior decisions and just make sure that you don't overrule them essentially without intending to do so. Thanks.
Mr. Love?
When there's this automatic protection that is associated with technical protection measures right now, and we would prefer a system where you'd apply, pay a small fee, and register the fact that you have a technical protection measure that you believe is entitled or should be entitled to legal protection, and that in the application for doing so, that you would describe how you would address legitimate use of users under exceptions, issues of interoperability, perhaps issues of sunsets on the protection, such as depositing unlocked keys with the Copyright Office, and that you would have a terms of service for the technical protection measure, which is describe the impact of the technical protections on what you believe the user rights to be. Something along that lines, that where you begin to sort of treat the legal protections, the TPMs, as a privilege, not a right, and that you associate the privilege with obligations on the person who wants the state to enforce the right for them, recognizing that there are these competing areas. I think that that would some of the problems you have right now of or people are looking for permit exceptions and things like that. I mean, sometimes it's because the practices in the TPM thing are so inconsistent with public policy, and it's just it's obvious that you want to have some carve out some serious, but people are always raising these issues like, well, do you anticipate all the problems and things like that? I think just starting with the idea that everything's protected and you have to kind of claw back the exceptions, I think that creates a lot of problems. If you sort of create the environment where you have to sort of make a case for the exceptions, or at least describe what you believe that you've made the case at a very minimum, I think it begins to make the whole process more manageable. Also, a little concerned about the relationship between trade agreements and what you're doing in this proceeding, because the government's involved in these trade agreements where you're creating expectations about what we have to do within the context of the trade agreements, and then they're creating these investor-state agreements where people can bring lawsuits against the or bring arbitrations against the United States around those things if their expectations aren't met and things like that. And I think that it would be important for the Copyright Office, to the extent that they're modifying the rules or changing the rules on this thing, so also to talk to the United States Trade Representative to make sure that they're ensuring there's enough flexibility in our agreement. So if we change our philosophy about how to do these technical locks on things across a wide range of industries, not just the motion picture industry or the book industry, but in these areas that involve automobiles and consumer electronic devices and all the other things affected by the trade agreements, that we're not in a situation where you're trying to do one thing where the United States Trade Representative is making that difficult.
Thank you. And that actually sort of anticipated a question. So are there any other examples around the world of that sort of system where, providing for a registration of TPMs that you're aware of? And might that implicate international obligations of the U.S.?
I think right now the closest model for that would be the obligation in the European directive that you have obligations to provide user rights in areas that are part of the directive, although I don't think it's really spelled out very clearly. And it's not the same as sort of registering works. I think, though, that the movement against registration and copyright across the board for everything has been a mistake. And I think the idea, you could make an analogy between the collateral damage and harm that's been done by having copyright always everything being protected copyright is on TPMs is exactly the same problem. It's just too sweeping, and the combination of no obligation on the person who's protected and the fact that everything is automatically protected, those things collectively create a lot of problems.
Okay, thank you. Mr. Geiger?
If I can respond to a couple things that Mr. Williams said. Part of the reason that we don't see a ton of litigation on 1201 and security research is because, for two reasons. One, a lot of security research is chilled and by 1201, so it actually doesn't get to the litigation stage. So we'll see researchers get cease and desist letters, and many times they are not able, just don't have the expertise to evaluate the legal claim, and it just doesn't go to litigation. And then second.
Can I interrupt? Is that, are you speaking academically or commercially or both? Because I know in the rulemaking there seems to be sort of a divide between the researchers for researchers' sake and those who are perhaps like unaffiliated with an organization, and then entities such as Rapid7.
So for folks that are unaffiliated with an organization, that's typically where the cease and desist letters tend to have the most impact. If you're affiliated with an organization, then you have more resources to draw on to evaluate your legal claims. We play in both worlds. We work a lot with independent security researchers and try to help be a steward to that community, but we also have our own researchers. And in cases where you have an institutional affiliation, a lot of times you just see it ignored. Right? You see the cease and desist letter just kind of ignored, and it's sort of well, if you want to go to litigation over this for real, then we'll do that. And often it doesn't get to that stage. Either way, the system is broken. It may have made more sense when it was enacted, but as it is now, it's not working. And we have, cybersecurity is a national priority. Everybody recognizes that. So why in the world would we wait for bad cases to be litigated? Two other points. One is when it comes to not violating any other law, most of these other laws, including the CFAA, provide a private right of action. It would seem odd to us if the security research is violating the CFAA, why suddenly the permanent exception protection should also fall away. The punishments under CFAA and other laws are already relatively harsh, so why add on to that with copyright? I don't understand why that would play into it. And in addition, if it's a matter of violating a licensing agreement, then you do have recourse through breach of contract to go after the researcher there. So there are other avenues that don't need to necessarily rope in Section 1201.
Can I ask you a more targeted question? Because I am hoping that these roundtables sort of focus us on potential areas of reform or why they may not be advisable. But if you contrast the encryption exemption with the security testing exemption, I think it needs to be with the authorization, whereas encryption, you just need to make a good faith effort. And I know in the rulemaking, you heard a lot about the bug bounty programs or front door policy or ways in which there is sort of a understood protocol or norms or ethics that one might go about in getting authorization. If we made some revision to call it a good faith effort to get authorization as opposed to a requirement, would that help you out? Do others see problems with that?
So unfortunately, no, and for a couple reasons. It's definitely better than a requirement, and our standard practice is that we do make a good faith effort to try to contact the vendor, whoever has the flaw. And however, that is not every manufacturer, not every vendor actually has a means of being of contact. And it is a policy that, in fact, the Department of Commerce is working now to try to get more adopted through its multi-stakeholder process. But it is not really the norm among industries right now. And especially with the Internet of Things, where we're seeing a lot of companies that are entering this computer space in that maybe had not had a lot of experience in it before, they don't necessarily think to have a vulnerability disclosure process, and sometimes it is very difficult to get in touch with them. The other problem with it...
Well, in that case, wouldn't you have made your good faith effort? Or
The other problem is that you don't always know how to contact the vendor. And some of the research that we do is entirely online. Some of it is automated. We have a Project Sonar that scans the entire internet, in fact, does it every week. And it is not always feasible to contact the owner. And it's often not feasible to contact, in the case of Project Sonar, where we're scanning billions of devices, there are millions of owners. How do you contact all of them? So it's a best practice, but it is not one that I think the protection ought to hinge on, because it doesn't scale. You don't always know the owner. Even if you do know all the owners, it doesn't scale, and it's not always the practice of every manufacturer to have an avenue. And so there is, we've experienced it, sometimes dispute over whether the effort was good enough.
I think we'd like to go to Mr. Moore and then turn to the next topic.
Just a couple of pretty quick points. It's difficult for me to figure out exactly what Mr. Geiger's company does. I don't know precisely what they do and how they do it. I would actually like to discuss that with him afterwards, in a nice way.
Anytime. Anytime. I didn't want to take up time on the panel, but I'd be happy to do it.
That would be useful. I mean, just a couple of things. Look, I mean, computer networks existed at the time this statute was enacted. Things are different now. Certainly, the connectivity of ordinary devices is expanding, but our members certainly are quite fond of the CFAA, for example, in its current form. And they are also quite fond of the DMCA in its current form. Again, I mean, a lot of our concerns are, they may not be as much with the legitimate activities that Mr. Geiger's company does. I mean, sonar to me does not sound like cracking. It sounds like looking. That's not something that would necessarily implicate the circumvention of a technological protection measure. And that's why I heard that, and that's why it struck me. I was puzzled as to how the DMCA would be implicated in a situation like that.
So I just used Sonar as an example of a large-scale security research program, and for the most part, Sonar is just looking. And we're looking at ports and website or web router and website connections that are not encrypted or that have appear to have no password protection and so forth. And CFA actually stops us from going further in many cases. But I'm mostly using that as just an example for the problem that you would have with scaling for a large-scale research project and something that you were able to provide notice to individuals for.
And my concern would be with a large-scale, something dubbed a large-scale research project that did much more than, let's say, walk around a neighborhood and see whose blinds were down. I mean, at that point, we would have concerns. We would have, obviously, security concerns, and we would have potentially infringement concerns as well.
Well, I understand that. I'm not really sure where the copyright infringement concern is there on your end, but let's say that it is a project like Sonar that is scanning for routers that are sending unencrypted traffic, or that there is a flaw in the implementation of the encryption. And so you'd want to check to see whether or not that flaw was present in these routers all around the world. And I would guess that you could probably find thousands of routers at least that meet this flaw. In order to find out that they are in fact flawed, then you may have to test it. And I don't see where the problem is for the availability of the copyrighted work. I don't see where the copyright infringement is. It'd be difficult to get authorization in order to do that beforehand or to inform the router owners directly after the fact. And it would not be covered currently by any of the permanent exceptions. And, sorry, go ahead.
You all are certainly welcome to continue this after the roundtable. I think did you have one more question on
Yeah,
security?
before we moved off that, I just wanted to open it up to anyone else who wanted to comment about these 3 permanent exemptions, and specifically the one for interoperability, 1201F, if anyone had thoughts on that. So, Mr. Dow?
Just 2 thoughts very quickly. One is, I think this goes to Mr. Williams' point that this notion of interoperability, I don't know what Mr. Geiger's company does either, but just listening to Mike, have every belief that what he does is in good faith. But what we've seen even in some of the CSS-related litigation is that we've had people who've tried to take advantage of the exceptions for things like security testing and interoperability, for things that really were just about removing content protection from movies and other entertainment. Unfortunately.
And so in those instances, they're doing it in the name of research, or how do they link that together?
Well, so for example, in the Corley case, you had a defense that was put forward that said that what was going on there was really just a matter of trying to make DVDs interoperable with Linux computer systems. Because they said there wasn't a Linux player that could play those DVDs. In fact, there were licensed Linux players at the time. But the problem was that the way they preferred to make those movies viewable on a Linux player was to remove the copy protection, remove the encryption so they would play on any player, right? That makes the movie interoperable by making sure that there are no protections, right? Now, the court saw through that and didn't see the permanent exemption as applicable in that circumstance. But it was an example of somebody who was not a good actor who was trying to leverage some of these exemptions for purposes other than the ones they were intended. And we need to be mindful of the ability of people to do that in the way they're crafted. The second point I was going to make, and this is sort of probably taking my Disney hat off and putting back on my former Judiciary Committee counsel hat, that this interaction between Mr. Geiger and Mr. Moore, I think, just highlights the fact that these exceptions in the statute were very, very carefully negotiated down to every word between the relevant impacted parties. If we just start going through and crossing out words, we start upending a balance that was struck. Now, whether or not this balance continues to work today is a totally separate question, but the notion that somehow we could just start rejiggering things and that we would maintain the type of balance that was maintained, I think is of concern. If Mr. Moore and Mr. Geiger go off and figure out what the right modifications are to it and it doesn't implicate the types of concerns I was referring to, that may be another thing, but I think this sort of counsels towards a consensus-based approach to these things.
Ms. Koberidze.
I wanted to pick up on something that Mr. Lowe mentioned regarding European directive. Europe went with another approach than the U.S. U.S. decided to give few exemptions and to go with rulemaking process. European Union went with given originally a longer list with exemptions, but some of the countries decided to provide a mediation process. And maybe with permanent exemptions under 1201, that could be an option for the parties to get into that mediation process. Like we just saw with Mr. Geiger and Mr. Moore, they are open to discussion, and that would be helpful. So, for example, it could be like the first step would be for the interested beneficiary of the exemption to come forward and contact the copyright holder and say, we would like to make certain uses under the permanent exemption. Do you agree or not? If they do not, then the intended beneficiaries could go and request a certain agency, in this case it would be Copyright Office, to help to accommodate the access or third-party assistance, whatever is applicable in this specific, under specific permanent exemption.
Thank you. I do think we need to move on. I want to turn to talking about proposals for new permanent exemptions, and I wanted to start with a proposal that we saw a pretty substantial agreement on in the written comments, and that would be an exemption for the print disabled and visually impaired. As you know, the current exemption applies to literary works protected by TPMs that prevent read-aloud functionality, or screen readers or other assistive technologies. I would be interested in your thoughts about whether Congress might consider making that specific exemption permanent. If so, whether the current language is sufficient or whether it should be altered in some way. And I'd like to start with Mr. Cazares.
I think that I first and foremost would be remiss if I didn't recognize the effort that both the publishing industry and the libraries have done in the last few years to try and ensure that accessibility is something that's incorporated from the beginning. I think Ms. Cox brought up a good point on the exemptions that the libraries really do rely on to ensure that assistive technology and other technologies used by the blind and visually impaired are available, and likewise the publishers have done great work with their members to ensure that products are being produced accessibly. Having said that, I think that it's safe to say that for people who are blind and visually impaired, that circumstance certainly isn't going to change. I expect to be blind 3 years from now. So I think that the discussion is worth having on setting up a permanent exemption. I think that the language that we have now is worth revisiting with all of the interested stakeholders. Accessibility has been something that has quite literally taken a village to try and bring to the mainstream. So I think that the discussions that we've spearheaded both with the libraries and the publishers and the discussion that we're having now is a good start. But I definitely know that the National Federation of the Blind is supportive of such permanent exemption.
Thank you. May I ask a follow-up? I just would be curious to know your views on sort of how the market, and you mentioned this at the outset of your statement, is responding. Have you noticed a change over time, an increase in accessible format copies becoming available in the marketplace, such that maybe the need to circumvent may be diminished?
So I certainly don't think that we're at a point where the need to circumvent needs to be diminished, particularly in the realm of education. There's still a lot of work that needs to be done to ensure that e-books and digital books that are produced, particularly with the DRM, are accessible. What we're finding now is that a lot of time authorized entities have to then take such materials and ensure that they're accessible. I think that we're making significant progress, but I don't think we're at the happy-go-lucky day where I can safely say that everything that is produced digitally, particularly in the literary realm, is accessible from the beginning.
Great, thank you. Ms. Cox?
So you've heard me say earlier, but of course we agree with the position of the National Federation of the Blind that these permanent exemptions are necessary. And I would just add a few points that as the Obama administration earlier this year submitted the Marrakesh Treaty for ratification by the Senate, also submitted implementing legislation, it's really important to note that if the Marrakesh Treaty comes into force, that in order to comply with the treaty and really make it useful, it would be good to have that permanent exemption to ensure compliance with the treaty. Additionally, as Mr. Cazares pointed out, that even though, yes, there are more works being produced digitally, it doesn't mean that those works are necessarily accessible. Especially in the educational realm. Our libraries work very often with the disability service offices to ensure that we are able to provide accessible formats of various textbooks, which are often not created in an accessible format from the start. You know, we would love for everything to be immediately accessible for our users that are print disabled, but that's simply not the case today. And just, you know, I think the example of the print disabled also ties into this question of interoperability, because oftentimes individuals with print disabilities have a specific device that they use, and while it might be accessible on one format, on an iPad, it might not be accessible on a Kindle, and it's really unfair to ask someone who is print disabled to buy 5 different devices to find the one that works for them. And this actually came up, I believe, in the 2006 rulemaking process, where the joint reply comments from rights holders groups like the AAP, MPAA, RIAA criticized the American Federation for the Blind's evidence showing that 4 of the 5 works that they looked at were not accessible to them. They actually found that 3 of those 4 were accessible. They just weren't accessible on the format that the platform that was being used to test this in the evidence. So I think it's really important to ensure that, especially for the print disabled, that you're not restricting that exemption.
Thank you. Ms. Bessick?
Microphone?
This is an appropriate area for Congress to act, because I think the history of the rulemaking indicates that this is an exemption that's regularly been sought and granted without a lot of opposition. And I think there are strong public policy reasons for raising it to the level of a permanent exemption. So I would favor it in general. Although, I can't say sitting here that the exact formulation, of a past rulemaking is the correct one, and that's something that we would have to look at. I do have some concerns about the, the accessibility discussion that we just had, and, because there's also the other side of the coin. You don't want to discourage the market for creating accessible versions for other types of devices as well. So there are both sides of that to consider.
Do you have a view as to whether a discussion about implementing a permanent exemption along this line should be limited towards sort of the general subject matter of the prior exemptions for the print disabled, as opposed to accessibility or assistive technology more broadly? I mean, we received written comments of an organization representing individuals with degenerative diseases, not necessarily related, so not necessarily related to ebooks or accessing books, but maybe playing a video game, for example.
At this point, I think because part of my rationale is that there have been a series of exemptions already granted, I would limit the print disabled. That doesn't mean that other groups couldn't seek in the future an exemption under the rulemaking, and perhaps at some point, that would be deemed worthy of a permanent exemption. But I think it would be premature to do that right now.
Mr. Williams?
Thank you. I think we would agree that this is an important exemption that's been in existence now for some time. I think you're also right to say there's generally consensus that it should continue to exist and be renewed. And at this point in time, the market isn't adequately addressing the problem, and that's why we don't oppose the existence of the exemption. I think the streamlined renewal process, again, is something that would be more effective at addressing this than trying to make the exemption permanent for a couple of reasons. The first is, my understanding is that there are formats in development that are going to roll out that will make this problem much less significant if it doesn't go away. There's EPUB 3 and HTML5, which I understand are both going to help address these issues. And so if that were the case and circumvention became unnecessary, then there wouldn't be a need to have an exemption sitting in the statute when we could just renew it through the rulemaking process. The other issue is that if the language does need to be revisited, I think that's something that we would be open to, but I don't think I've seen any specific proposals about how that needs to be done. So that's something that could be worked out before the next rulemaking or during the next rulemaking. If we could come to consensus, we could address what the changes are that need to be made. And again, if you put it in the statute as it currently is drafted or in some new, slightly revised form, then that's how it will be. And the rulemaking, the benefit of it is it's more flexible than that. You can revisit it. You can figure out, well, if it's not fixing the problem, let's get together and fix the problem. So that's I think, the better way to address it.
Although, I mean, a permanent exemption wouldn't preclude, future requests administratively.
No, I agree with that, but I also question whether it makes sense to go through the whole legislative process of putting new permanent exemptions into the statute when it's unlikely they're going to end up being the ultimate solution. And I think that's why Congress created this rulemaking, is that it knew there's going to be a lot of things that come up that we can't address in the statute. And so, Title 17 is very long already. And if we start putting new things in it that very quickly become irrelevant or become no longer capable of addressing the problems, then I don't think that that's a helpful way to go about it.
So I hear you, but Congress also implemented a variety of exceptions to the prohibition on circumvention, which are these permanent exemptions. I mean, should we treat these on par with a continuously renewed exemption, or where's the line? Why have one for encryption but not have one for assistive technology?
Sure, and I think you have to assess every issue as it comes up. As I was saying earlier, I think a lot of the permanent exemptions appear to have largely done their job, and that litigation is not taking place that results in bad outcomes. And I think there's a lot of people who seem to have concerns about the scope of these exemptions, but there's not a lot of evidence that if it actually got litigated, they wouldn't have addressed the problem. But that being said, the fact that no one is content with them, to me, indicates that no matter how we worked through over the next couple of years creating new permanent exemptions, someone's going to figure out a reason why in a couple of years they are worried they're not going to work right. And they're going to come to you with those concerns. And so I feel like that renders the legislative work that everyone would have to do a little more suspect, because there's already a process that, as I said yesterday, is working quite well, where the office is able to address these things. And if you can get them renewed in a much less burdensome fashion, that to me is far preferable to going the legislative route.
Mr. Love?
Thank you. I don't know if you're aware of this, but I spent maybe 5 years of my life working about half time on this, on this issue. So we followed the debates on it. I'd call attention to, if you look at certainly the temporary thing has been a problem for the groups. There's been years when almost no evidence was provided for the renewal just because it was such a burdensome proceeding, and it would have been, and there was a recommendation by the professional staff to get rid of the exception because the burden had been met in the administrative proceeding. But I think the Library of Congress wisely extended the exception anyhow because they recognized that it was just a failure of the process and that the need was still there. So I think the idea of having a permanent exception is appealing, or at least a more durable exception in some ways. The language in the treaty that people have referred to, which says that you shall take appropriate measures to make sure that beneficiary persons can enjoy the limitation exceptions that they should have, is kind of the level of generality where maybe the specifics of how that's done can be done more administratively. I'm sympathetic to the idea that rigid statutory frameworks are not necessarily that appealing in a lot of cases. I know that there was an earlier exception for the blind that had a commercial availability provision in it, and there was a letter on the 21st of September 2012 from NTIA to Maria Palenti that discussed this issue, and some of this is I think, described in a note that Krista Cox is the author of June 7th, 2013, Marrakesh note number 4, when Krista was working with us, was addressing this issue. And I would recommend that memo because I think it's quite well written, and I think it's informative on this point. But it's the finding by NTIA was that the interoperability problem had gotten worse, not better. The hopes was, we always hear these talks, licensing will solve the problem, technology will solve the problem, blah, 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 blah. But then the thing that Krista mentioned earlier about the cost of obtaining different devices, also in the context of the treaty, you saw people making these presentations in the treaty negotiations that would get up and they would show you what was considered to be accessible. Like one blind person from South Africa, he had a PDF read. He would read an entire page of text to him in the sort of permitted format that they had accessibility, and he was just trying to get the footnote at the bottom of the page. And he'd try and copy it down after he'd hear it, and then he'd have to start it again and again, and he'd have to do it like several different times because the reader he was using didn't allow him to stop or cut and paste and things like that. Whereas other readers that people were used were designed more functionality and were really easier to use and more effective for people. Not only could you speed up the process quite a bit, but you had other abilities to sort of utilize the text in different ways. I think people that are not really familiar with it, I wasn't that familiar with it myself when I started to learn about these things, just don't really understand how high-tech some of the assistive technologies really are and how idiosyncratic they are for the users and things like that. So for that reason, NTIA really changed its position on the commercial availability because they just didn't think it was really a workable standard. Now, that said, I think this balance between having a permanent mandate to do something that makes people equal in the way that they're supposed to is the right approach. And then being able to fine-tune the details of how the exception is implemented over time, probably a good idea. My mother's deaf. She was one of the people that was excluded from the Marrakesh Treaty because the motion picture industry insisted on that in the negotiations. Her situation's better today than it was in the old days because we used to have to buy separate devices to do kind of captioning, and now you can get that more, even Netflix has it these days, which is kind of nice. But it is the case that it was, I think, a disappointment that the Marrakesh Treaty on print disabilities was as narrow. It was a political decision, but it also permitted countries to implement them more widely. And I think U.S. law is wider in a lot of areas, certainly in the area of education. So I think that striking the right balance as to how inclusive it is, but also recognizing that maybe the exceptions are maybe better understood in some areas of disabilities in terms of the overall the effect on all the stakeholders is probably accurate as well. So, I think maybe sort of arguing against myself a little bit, like maybe given like accepting that you sort of know what you're doing in some areas and you know you should be doing something in other areas, but maybe you're not quite as confident you know what that thing is just yet is probably realistic.
Thank you. I think we're going to go to Ms. Kobaridze and then back to Mr. Cazares.
I believe there is a strong support for permanent exemption for print-disabled people, and we have rulemaking records since 2003. We have case law, Authors Guild versus Health Trust. We have Shafi Amendment, and we have also international obligations under Marrakesh Treaty. And although, despite all these regulations, print-disabled people still cannot benefit from the exemptions that are granted within the rulemaking proceedings. And this is because they need accessibility and they need third-party assistance. And I think it would be very important when we consider permanent exemption to consider these two issues: how to facilitate accessibility and how to facilitate third-party assistance, whether it will be through mediation process, as I mentioned, with the copyright holders, or whether it will be with help of the Copyright Office, or maybe there could be a third solution to create a separate management organization similar to Sound Exchange in the music industry, which will help to manage third-party assistance issues. Thank you.
Thank you very much. Mr. Cazares.
That a couple great points have been made. I agree in part with Mr. Williams. I think that the forthcoming of EPUB 3 and HTML5 are going to kind of revolutionize the way accessibility is approached in the mainstream. But I also want to address the fact of the permanent exemption. The fact is that people with disabilities, particularly the AFB, the American Foundation for the Blind, and other folks have been requesting exemptions that have been, by and large, being renewed with little to no opposition because the circumstances really don't change for people with disabilities. I think given the fact that we have a large number of people who are blind or visually impaired in this country alone guarantees a permanent exemption. I don't see the need until the process is reformed for the rulemaking process. I don't see the reason why people with disabilities, people who are print disabled, have to go through the burdensome process of requesting for and waiting to be granted another 3-year exemption. I think that this particular circumstance, given the situation of blind and print disabled Americans, warrants a permanent exemption.
Thank you very much. I think we had quite broad agreement on that topic, which is encouraging. We're getting close to the end, and so I think we just had one or two sort of suggestions for permanent exemptions that we wanted to ask your views about. One proposal that came up in the comments was to make the current unlocking exemption permanent. Be interested in your views on the advisability of that. Mr. Dow.
I think it was Mr. Adler in the previous panel that read some from the legislative history and the contextual part of the unlocking, the circumstances of the unlocking legislation. And I think that counsels towards an approach that says a permanent exception for that type of thing is really not the way to go. And I think that's not unique to unlocking per se. I think that really applies when you're dealing with very technologically specific items in general. But the one thing on the unlocking legislation specifically was that the unique circumstances of that was that we knew what that meant. We knew what it meant to unlock a phone. We knew that what it meant was the entry of a code, right? It was a handful of digits that could be entered in, and the only thing that it resulted from the entry of those digits was that you could connect that phone to a network. It didn't expose the content on the phone. It didn't expose personal information. There weren't privacy interests that were affected. There weren't copyright interests. It was a very narrow thing. But we didn't know what that was going to mean for the next device, right? I mean, that was one of the issues when we talked about should this be expanded into the context of tablets and other computing devices, right? Does circumvention for the purpose of connecting to the device mean the same thing in those contexts? Does it mean simply that you can connect that device to a network, or does it mean that all of a sudden it does implicate some of these other interests that didn't exist at the time of the cell phone unlocking legislation? And so I think the legislative history speaks specifically to that. It talks about that being a unique circumstance and why Congress was comfortable doing it. And I think it speaks towards why, in the context of trying to look at that for other devices in other contexts, it really requires a specific focus and one that's uniquely suited to something like the rulemaking as opposed to the legislative process and a permanent exemption.
Thank you. Mr. Love? Oh, that was from before? Okay. Anyone else want to weigh in? Ms. Kobaridze?
I support this type of exemption, although I understand it will be very hard to agree on the language, especially since, as was mentioned a lot today, new devices are coming in, and it's very hard to predict what kind of users and what kind of uses will need to be exempted. But we need to start discussing it now, because as the last rulemaking showed, it was the beginning. All those devices, smartwatches, TVs, and medical devices. Now we will have Amazon Alexa, and then we will have smart homes, and everything will be connected. And a lot of security testing would be needed, a lot of privacy issues will arise, and those will be not concerns of the copyright law by itself, but because a lot of those devices and technologies use copyrighted material, which is computer programs, it would be helpful to at least start drafting some permanent exemption that will help us to start moving in that direction of unlocking certain devices for certain uses. Maybe it will be very narrowly tailored, but we can at least use the rulemaking record to find out which ones are more important to make now.
Can I ask just one follow-up question, then I think we're going to move to another proposal, but just should we consider the specific narrow case of unlocking your phones differently than the broader jailbreaking classes, right, where you're opening up an activity, a host of devices, the technology may work differently, sort of going to Mr. Dow's point, and we may not know exactly what software is being implicated for that? Should we treat unlocking differently than jailbreaking?
Yeah, when I'm talking about unlocking, it means I'm trying to just cover all the aspects of, including card tinkering, and including jailbreaking. I don't expect all of those could be even become permanent exemptions, but at least wireless devices, just unlocking to be able to change carriers. And it's interesting how the rulemaking itself resulted in changes on the marketplace, because now, even if we look at the Amazon Alexa, the system is open to third-party applications, and we might not need jailbreaking for that specific device. But at least changing carriers, I think it could be very helpful to have for the mobile devices.
Okay, so I think I'll go to Mr. Williams next, and then I think in your answer, you sort of open up where we were going to go next anyways, which is sort of repair and auto tinkering. So if you would like to comment on that, also feel free, since we're running short on time. Mr. Williams?
Thank you.
Thank you. Just on your last question about how to handle jailbreaking, I would be opposed to trying to create a permanent exemption for jailbreaking for the reasons that Mr. Dow expressed related to unlocking, and also because even within the context of the rulemaking, there have been things referred to as jailbreaking proposed that the office has concluded should not be granted. And going back to what I referred to earlier and Mr. Dow referred to, the Linux situation with DVDs, there are a number of times that people have sought to impress on the office that they were entitled to access an expressive work on any device of their choice, and the office has concluded that's not correct. And so to try to craft a permanent exemption for jailbreaking the things that the office has concluded you should be able to jailbreak, but not sweeping in the things that you've already concluded you should not be able to hack, and then also address future devices and future products and services, I think that would be a very unworkable task, so I'd be opposed to that.
Okay, thank you. Mr. Levin, I'll ask you to keep it short, just because we are running out of time for all the next commenters.
Right now, the Copyright Office is the decider on a lot of these things, and then other agencies petition the Copyright Office with their concerns. In the FDA proceeding right now, there's been requests that the FDA is a regulatory thing, regulate some of the technical protection measures on medical devices are as part of a broader work they're doing on medical devices and hospital networks in terms of cybersecurity. I'm just wondering if in some cases it makes sense for the Copyright Office to farm out some of, like in the jailbreaking case, I mean, maybe I'm not sure that it makes sense for the Copyright Office to be the be-all and end-all of the decision-making. In terms of future way you might imagine doing this, or should this be something that you envision that other agencies could, I mean, is it always have to be your rulemaking authority, or could another agency basically be?
Thank you. I mean, I do take your point. And in fact, the last rulemaking, the Copyright Office did solicit some viewpoints from other agencies when commenters had suggested that it may fall under their bailiwick. I think the discussion of jailbreaking is getting a little fuzzy, whereas in the rulemakings it's been referred to opening up a device in order to install different apps on it, so that wouldn't necessarily extend to medical devices, but I do take your point. And Mr. Moore?
Just quickly, I mean, I think, we, SIA has had some experience with trying to move, I think, in hindsight, a bit too quickly. So we were supporters of UCITA, and I was not representing them, but I was at many of those drafting meetings. And what you had was somebody trying to draft a statute that codified practice that would literally change every 2 months. We would have new language proposed because back AOL did something or CompuServe did something, and it just never stayed still. And I think in terms of, for a lot of the kinds of things that we are talking about, that the type of flexibility, particularly with, as Mr. Williams mentioned, the kind of streamlining that we've discussed and which enjoys pretty broad support, with that type of flexibility, I think you will produce better policy results.
Thank you. I know we're running out of time. I have one final question. Others may have other questions about just some of the other permanent exemptions. If anyone wanted to weigh in on them, there's one, for example, for privacy. You know, if we can beat the hypothetical to death right now, is it working if you want to turn off your smart refrigerator so it doesn't spy on you? Or protection of minors, analog devices. There's one for federal agencies. Does anyone else want to comment on potential reforms to those? Mr. Perry?
Thought you'd never ask. So
we appreciate your patience.
That's okay. I won't repeat what was said in the previous session. Since our client is a player in the auto aftermarket industry. We haven't, to be honest, talked at length with our client about the permanency of the exemption. I think it's, and I'm not really sure what a streamlined renewal process would be as distinguished from permanent, exactly how it would work. I think if we liked the exemption, we would want it to be permanent. We don't like this exemption as it's written, so we haven't spoken about it very much. The Class 21 exemption, as I pointed out in the prior session, sort of morphed from as it was proposed to as it ended up. And some of the wording in there with respect to on behalf of the owner or authorized owner, some of the wording in the exemption essentially for the, $200 billion auto aftermarket industry sort of left them basically hanging. And a point I did not make in the prior session was, and this may be the only exemption of all the classes, the Class 21 exemption really doesn't kick in for, I think, 12 months from when it was originally promulgated. And it also has an explicit sort of directive over to the DOT and the EPA, which sort of ties in with a point that Mr. Geiger made earlier about, those laws are there. Do we need to have the Copyright Office in an exemption essentially give sort of a tentative shout out over to the DOT and the EPA saying, we just want to make sure that what we're doing here isn't going to violate your laws, so just to be safe, let's not make any of this happen for 12 months. And the effective result, at least for the aftermarket industry, was to basically look at this exemption and say, well, that basically didn't really give us much of anything, except maybe another year to wait and see what litigation is going to ensue, what kind of lobbying is going to take place. And, if you're, however, if you are a car repair enthusiast, starting, I guess, in October next year, if you want to circumvent and fix your windshield wipers and break into the chip that exists in there, I suppose this exemption is for you. The reality is that it doesn't help the average person. It doesn't help any of us, the average person who drives a car who goes to their local mechanic, which is about, I think, 70% of automobile aftermarket repair is done through, your local mechanic. It's not done at the dealer. Of course, this ties in hugely to automobile manufacturers and big auto and all the tensions between the automakers, their own dealers, where there's great tension, the aftermarket, where there's additional tension. And to Mr. Moore's point earlier, I think we fully agree. The expression versus functionality, that dichotomy, it's not easy. It's not easy at all. Some cases, I think, with cars are easier to see than others. If you're talking about a windshield wiper or a door, the button that brings your windows down. But there are a lot of gray areas in this. So. Sort of a long answer to address a variety of issues that came up earlier, but this particular exemption in Class 21 is so watered down and tentative that there's no reason for us to want this to be permanent as written.
Thank you. Ms. Kobaridze?
I just wanted to add that even ask whether the wording in our permanent exemptions subject to privacy and security and other regulations will resolve the concerns expressed today and earlier in the roundtable regarding privacy issues and safety issues. So will it give some deference to other agencies who are best positioned to address those issues?
Thank you. Mr. Love and then Mr. Dow, and I think then we're going to open it up to the audience.
If it was possible, we would think it would be useful if the Copyright Office would have a permanent exception in this, to the extent of remedies to anti-competitive practices, or possibly, you mentioned privacy, maybe that's another area too, that the Federal Trade Commission would spell out. And it's like sort of the idea of not just having this office, but maybe kind of a decentralized area where, in addition to whatever you do, that another agency, such as the Federal Trade Commission, which deals with anti-competitive practices and interoperability issues on a regular basis, may play a role. And also, I said this earlier in terms of medical devices for the FDA. I think if the FDA asserts some kind of role in the area of security of medical devices and networks, I think that they should be able to extend the benefits of an exception. And that I think that should be kind of hardwired into the process. And the last thing I would say, the final thing would be on the National Science Foundation. I think they should be able to make similar recommendations as it relates to artificial intelligence systems, which is a topic which we addressed in some of our comments earlier.
Thank you. And I just want to make clear, currently under the statute 1201I is an exemption in the Copyright Act for the protection of personally identifying information. So that's an existing place to either accept, build off from, et cetera.
Mr. Dow.
Okay, just very quickly, one thing that I think we really haven't touched on has been the incentive value of the rulemaking process. The rulemaking process in part was adopted to give copyright owners an incentive to use technological protection measures to apply them to protect their works in ways that can accommodate non-infringing uses, because there was this process that said if you use these things in ways that that cut out non-infringing uses and impair that, then there's the likelihood that you'll wind up with an exception that's going to allow people to hack into your technological protection measures. There's an incentive built in there to try and be responsible about the way you apply these. And I think we've seen some of that. There was a comment, I think, a few minutes ago about maybe some movement that we have seen in the market for accessibility and perhaps having something to do with some of the rulemaking proceedings with respect to unlocking and how that may have driven the marketplace in some ways, whether we're talking in security research, whether we're talking in unlocking and jailbreaking, whether we're talking in licensing. And we heard Mr. Turnbull earlier talk about the willingness to talk about solutions to provide licensed mechanisms to achieve these things because the backstop alternative really isn't appealing. The rulemaking process, the ongoing nature of it, provides those incentives. Permanent exceptions really don't provide those incentives. You have a permanent exception, the incentive is really to say, okay, well, I guess we have nothing there. That's just the way it is, and there's no incentive to work going forward. So I think it's just worth remembering that there was a purpose to be served in an incentive nature of the rulemaking. I think it works. I think it had some impact, and I think there's value to it.
Thank you. We are over time, so I think we're going to have to leave it there. Thank you all very much. This was very helpful. And now our final session is an audience participation session. We have a microphone at the back. Oh, here it is at the front. And so if you have signed up, you're welcome to come forward and ask any questions or make any comments either about this particular topic or any of the topics that we've talked about. And you can still sign up.
Do we have anybody who's already signed up who wishes to speak? No. No. All right. All right. Head on up.
And if you could just, yeah, right.
I can lean down.
If you could just identify yourself.
Yes, of course.
I know
Yeah,
who you are.
absolutely. Brandon Butler from the University of Virginia Library. I just wanted to chime in earlier. There was a discussion about the scope of Section 108 and the question of whether, in the context of preservation activities, one would need to necessarily violate the ban on circumvention for purposes of copying as distinct from for purposes of access. And the answer is absolutely yes. Best practices for preservation and for access include to make multiple copies in different formats, often in different locations, so that, for example, if you don't want to be pulling up an emulator of an outdated DRM thing and the original file every time a researcher wants to read that thing that was on Salman Rushdie's laptop. What you would do is do that once, export that content into an access copy, and then try not to ever have to do that again so that all that stuff stays safe and not changed by the processes that you're applying in order to preserve the thing.
Thank you very much.
And can I say one other thing?
Sure.
Because I was not on the earlier panel about, the first panel yesterday, I wanted to weigh in a little bit about the question of competition issues and non-copyright interests that come into play in the context of 1201. I heard someone mentioned earlier on this panel, I think, the notion that other agencies should be able to weigh in, and I just wanted to agree with that. If the question is, if we're really thinking about overhauling the whole 1201 system, changing the legislation, not just thinking what can we do without changing the legislation, it would be great to have, the committee, the agencies that really know cars, be the ones that drive, so to speak, the process that has to do with cars.
Right. I mean, I hate to put you on the spot during open mic time, but currently there is consultation with NTIA and other agencies can participate in the rulemaking. I think you saw a lot of them did reach out to the Copyright Office, or we solicited them. So, is it broken and in need of fixing, or is it sort of working and you're just saying, I acknowledge this is happening and that's okay?
I think there is a real risk that where the interests at the heart of the issue are, car safety or consumer safety or competition, that having an agency that deals routinely with copyright issues and with people who care about copyright issues in the driver's seat, consulting the people But ultimately, the last word is in the copyright relevant agency. Seems maybe like something that is not ideal. If we could move the driver's seat over to the other agency, and then they would consult with you, so you could weigh in and say, no, there's not a problem for the copyright industries, the primarily copyright-oriented industries. This is about cars. It would make more sense for them to control and to consult you than the other way around.
Yes, I mean, I think the office is probably, in our defense, tried to stick to the copyright interest or thinking of it under the title, of the Copyright Act. But that's good to consider.
Can I make a quick point on that, which is that we're not really seeing the agencies that have relevant expertise in these areas hold back either. So it's not as if, though, 1201 is keeping these agencies at bay and they're not issuing their own regulations or their own legislative proposals to enhance car safety or prevent hacking or circumvention because of 1201. In many cases, we're seeing both move forward. In the case of the FDA, they just released their aftermarket cybersecurity guidelines for medical devices. We saw NHTSA come out with, or at least support legislation that would have addressed hacking in cars. So it's unclear to us why, what benefit 1201 is serving for these agencies if they're coming forward with their own proposals, or in many cases have existing regulations anyway.
Thank you. Mr. Adler?
At the moment, my name is the only one on that sheet back there, just so you know.
Oh, okay.
Yes, I just wanted to make an additional comment. The discussion about the accessibility exemption, I think, was a very interesting one. We, as Mr. Williams indicated, do think that if we get the streamlining process right for renewal, that renewal with respect to the exemption is more appropriate for all the reasons that were mentioned about flexibility, and particularly because of the fact that the market is changing. It's not changing fast enough. It hasn't changed to the point where it is satisfactory, but it is continuing to change. And that's the reason why commercial availability was always discussed as an exception to the exception, even when we talk about the Chafee Amendment. And I would point out that, for example, the importance of access controls cuts in many different directions. For example, we helped to validate the legitimacy of Bookshare, which was an authorized entity under the terms of the Chafee Amendment that became the first authorized entity to exist online and to be able to provide access to accessible format copies of works in digital forms on a subscriber basis. And we supported that. And it was worth pointing out that Bookshare uses access controls, such as encryption, to make sure that when these materials are being delivered to beneficiary persons who are entitled to use them, who need the accessible format copies, that they're being delivered to the right people. I would also point out that there was a lot of discussion about the Marrakesh Treaty. With respect to the TPM provision of the Marrakesh Treaty, it's generally the view that U.S. law already complies with that language precisely because of the exemption that has been created and renewed in the 1201 rulemaking process, as well as a result of the Chafee Amendment itself. But with respect to the comment I just made about Bookshare, I would also point out that there's an agreed statement that goes along with the Marrakesh Treaty that, in referring to the TPM section, specifically says that because the ability to transport across national borders accessible format copies of works is what the treaty provides for and intends to be able to facilitate, this language was agreed upon. It's understood that to distribute or make available accessible format copies directly to a beneficiary person in another contracting party, it may be appropriate for an authorized entity to apply further measures to confirm that the person it is serving is a beneficiary person and to follow its own practices as described in the article that delineates what an authorized entity is. So access controls are going to be important in order for the Marrakesh Treaty to be a success, to make sure that not only can accessible format copies be delivered across national borders all around the world from an authorized entity in one country to another, but as the treaty also provides, from authorized entities in one country directly to beneficiary persons in another country without having to have the intercession of an authorized entity. So I would also just mention that we have emphasized the importance of making sure that people understand what an authorized entity is, that an authorized entity indeed is willing to undertake what is necessary to make the Marrakesh Treaty a success and to facilitate its purposes properly. And I hope that we will have support from that with respect to others who commented favorably on the notion of the importance of an accessibility exemption in the 1201 process.
Thank you very much.
Hello, my name's Derek Manners. I'm from the National Federation of the Blind as well. I just wanted to comment briefly. I think there's a lot of agreement that the accessibility exemption is important. I think it's nice to hear that we're sort of debating about how to best preserve it and how to make it easier for everybody. I think that there's widespread agreement about that. One point I would like to make, though, is that Mr. Williams in particular indicated that the rulemaking process encouraged parties to work together. And I don't think that a permanent exemption would discourage parties from continuing to work together, in particular because many of the entities, third-party entities that have been discussed that have to make things accessible for the blind and print disabled have legal obligations to do so under Sections 504 of the Rehab Act and Titles 2 and 3 of the ADA. And so there will be a continuous dialogue on how to make sure that that's done well because they have a legal obligation to do so. And that's going to require buy-in also from the publishers and manufacturers to make sure that it's not being, like Mr. Adler was talking about, that there are controls to make sure that it's not, being abused or that the copies aren't getting leaked out. And so I don't think that the permanent exemption would preclude continued efforts to work together to ensure that blind people have access to accessible material while still protecting the interest of the stakeholders. Thank you.
Thank you very much. Did you have a?
Yeah, I wanted to clarify that, I agree with Mr. Adler that we can comply with our treaty obligations by renewing this exemption, ensuring that this exemption continues to persist. My point was simply that having a permanent exemption really makes a lot of sense, and it would ensure compliance rather than risk, at some point that the exemption is not granted in the future.
Thank you.
Good afternoon. I'm Raza Panjwani from Public Knowledge. There are just a few general comments I wanted to add based on this panel and some of the prior panels. I would encourage the office as it's undergoing the study to adopt a lens of asking what was the bargain in Section 1201 between rights holders and the public, and is that bargain and the assumptions underpinning that bargain about the marketplace and the incentives actually functioning. And I think a great example of considering that is that throughout the discussion, we've heard some folks say that we think the exemption process is working fine. We think the renewability discussion is academic. And most of the folks taking those positions are the folks on the rights holder side. And I think it's important to realize, as Professor Tushnet put it yesterday, that there are asymmetries in the process. That if the process is falling short of its goal, for example, of providing the exemptions that are necessary to the public, that leaves the rights holders whole in a sense, in that the ban is working, the 1201A prohibition on circumvention is still working. The process only isn't working for them when the exemptions go too far. And I think it's worth sort of noting that. Because especially I think the discussion about the renewability being academic, I think is important to realize because there have been cases where exemptions haven't been renewed. And I think for those on the proponent side, it's not academic, that there is a risk of an exemption not being granted, that the burden is on them to provide the proof necessary to get the exemption. So I don't think that's an academic discussion. And finally on that point, and especially tying into the accessibility discussion, the example that Mr. Love brought up of footnotes not being accessible, that might be a case where someone might say, well, 95% of literature is accessible. That's just an edge case. When you're the user, and that particular case implicates you, it's not an edge case. That is a failure of the system. And I think the exemption process and the user carve-outs and the permanent exemptions aren't meant to cover those edge cases in particular. So I would urge the office to consider, in terms of evaluating what the burden of proof should be, is considering that edge cases don't necessarily mean the system is working. Thank you.
Thank you very much. Did you have another comment? No. Okay. That's okay. Anyone else? Ms. Kobaridze?
Just a quick remark regarding accessibility. So the rulemaking exemption for print-disabled people was renewed since 2003. Today, now it's 2016, and still there is statistics that over 90% of the books are not available in the form for print-disabled. And even tech companies like Microsoft, in their comments, they agree on that. They feel and they acknowledge that they were not able to accommodate all the needs of the print-disabled people.
Thank you. Mr. Love?
Well, I want to mention I was contacted recently by someone who supported our work in the past in different areas, and he asked me a bunch of questions about artificial intelligence, and I guess he was following a lot of things that you begin to see more and more in the literature of concerns about the potential, really almost existential threat, or at least in some people's mind, these kind of things represent different points of view. But then there's like a wider range of things about just as we get enveloped more with software, we barely understand what's going on in our lives. I mean, we're being told what movies to watch, or how to drive to work. I mean, it's just become such a huge part of our life these days that this idea that you need to audit and monitor and understand better these forces which are shaping our lives. I don't think people are really kind of caught up with like how different life is today than it was 5 years ago, 10 years ago, or 20 years ago in terms of the relationship between us and software. And I think that it's important to realize that being able to look under to have somebody have the authority to basically sort of take a look under the hood to sort of see what's going on is going to become more important, not less important. So to the extent that you're making the system more leaky, not less leaky, I think that's a good thing, not a bad thing. I just wanted to say that.
Thank you very much. Oh, Mr. Williams.
Thanks. Briefly, I just wanted to return quickly to something the gentleman from Public Knowledge just said about considering, is the bargain that was struck in 1998, is that being met, and our rights holders fulfilling their end of the bargain. And I think if you look through the several pages of our initial filing in this proceeding and in all of our rulemaking filings, you'll see that there is just a vast array of new products and services that have hit the market, and that my clients have been meeting their side of that bargain to the best of their ability. And I just wanted to make sure that was on the record, that I think consumers have benefited greatly from the existence of 1201, that all kinds of products and services that no one had thought would be available have been made available. Thank you.
Thank you very much. That concludes today's session. Thank you all very much.
This has been a presentation of the Library of Congress. Visit us at loc.gov.